Hello and welcome back to our channel where we break down complex financial concepts into easy to understand lessons. Today, we are diving into an important topic: jurisdiction in demand guarantees and standby letters of credit. Understanding jurisdiction is crucial because it determines which court or arbitration tribunal has the authority to resolve disputes arising under these financial instruments. So, let's get started. Jurisdiction refers to the power to decide a dispute related to a demand guarantee or standby letter of credit, or to issue an injunction. A national court that has authority to decide such disputes is called a competent court. In some cases, arbitration tribunals may also have jurisdiction, but only if explicitly agreed upon in the terms of the instrument. If there is no express agreement on arbitration, then legal disputes will be handled by the competent court. Now, to determine jurisdiction, the first place to look is the demand guarantee or standby letter of credit itself. If there is an express jurisdiction clause, such as the demand guarantee is subject to exclusive jurisdiction of English courts, then disputes will be resolved by the High Court in London. However, if the instrument says nothing about jurisdiction, things become more complicated. Legal advice is often required to determine the appropriate jurisdiction, and the applicable law may differ based on the country involved. If a demand guarantee is subject to URDG 758 but does not specify jurisdiction, URDG Subarticle 35A provides that disputes between the guarantor and beneficiary must be settled by the competent court in the country where the guarantor's issuing branch or office is located. Similarly, under Subarticle 35B, disputes between the counter guarantor and the guarantor must be settled in the country of the counter guarantor's branch. This setup can create conflicting legal outcomes. For example, a court in guarantor's country may require payment to the beneficiary, while a court in the counter guarantor's country might rule that the counter guarantor does not have to reimburse the guarantor. One way to mitigate this risk is to include an express jurisdiction clause in both instruments, ideally selecting the neutral third country for arbitration or court jurisdiction. For demand guarantees that do not incorporate specific rules like URDG 758, determining jurisdiction becomes even more uncertain. In many cases, the jurisdiction may default to the location of the defendant, but this is not a guarantee. If a dispute arises, seeking legal counsel is often necessary. To avoid uncertainty, it is advisable to include a jurisdiction clause explicitly in the demand guarantee. If you are drafting a demand guarantee without applicable rules, always include a jurisdiction clause along with governing law provision. A good example of this would be: this standby letter of credit is subject to English law and to the exclusive jurisdiction of the High Court of Justice in London. Such a clause helps avoid legal ambiguity. Now, the relationship between ICC rules and governing law. Even when courts or arbitration tribunal respect the terms of the instrument and applicable rules, they still interpret unclear provisions according to local law. Courts may even imply certain legal provisions if they do not explicitly cover in the instrument or in the applicable law. This is why precise and clear drafting is crucial to avoid disputes and legal surprise. One major aspect not covered by ICC rules is fraud. URDG 758 or ISP 98 or UCP 600 do not address fraud. But disputes can arise over whether a demand was made in bad faith or contained false information. Since ICC rules do not provide an answer, courts and arbitration tribunal will rely on local law to resolve fraud-related disputes. We will discuss fraud in detail in an upcoming video. So, what have we learned today? If a demand guarantee or standby letter of credit does not include a jurisdiction clause. Identifying the competent court or arbitration tribunal can be challenging. URDG 758 provide guidance, but conflicting court ruling are still a risk. ISP 98, on the other hand, offers no jurisdictional framework, making it essential to include a jurisdiction clause when drafting a standby letter of credit. Ultimately, including clear governing law and jurisdiction provision reduces legal uncertainty and mitigation of risk. So that's the end of today's section. If you found this video helpful, make sure to like, subscribe, and hit the notification bell so you don't miss our upcoming content on fraud and financial instruments. Got questions? Drop them in the comments below and we will be happy to help. Thanks for watching and see you next time.